As some of you know, it's been advertised in the publicity for this event. I am not Catholic. I have many wonderful Catholic friends, and my mother-in-law is Catholic, but I am a member of the Church of Jesus Christ of Latter-day Saints. And it's really been a wonderful privilege for me to travel around the country and meet with Catholics and members of other religious groups that are worried and concerned about the threats that we see to our religious freedom in this day and age. It's been wonderful to see that we can all unite in a common cause to defend our religious freedom. And so in that spirit, I'd like to frame my remarks with two quotes from two recent addresses that were given on religious freedom. One of them is from a leader of my church, and one is from a Catholic cardinal, and I'll save his quote for the end. But I wanted to start with this quote from Elder Dallin H. Oaks, who's one of the 12 apostles of the LDS Church. And this is what he said, and he had in mind this very idea of people of different faiths joining together to fight together in defense of religious freedom. And this is what he said: "It is imperative that those of us who believe in God and in the reality of right and wrong unite more effectively to protect our religious freedoms, to preach and practice our faith in God and the principles of right and wrong he has established. All that is necessary for unity and a broad coalition is a common belief that there is right and wrong in human behavior that has been established by a supreme being. All who believe in that should unite more effectively to preserve and to strengthen the freedom to advocate and practice our religious beliefs, whatever they are. We must walk together for a ways on the same path in order to secure our freedom to pursue our separate ways when that is necessary according to our own belief." And so it is with this idea that we can unify together and stand to defend together our precious religious freedom that I'd like to talk tonight about some of the threats that we are currently seeing, that we are currently facing, that we're currently litigating in the courts of law around this country. And those are primarily four. I hope I will be able to get to them all tonight in the short time I have with you. But they are four primary threats. First, government mandates that force religious institutions to act contrary to their doctrines. Second, the threat to the autonomy of religious organizations to choose their leaders. Third, the threat to the right of conscience of individual professionals. And fourth, the threats to the presence of religion in the public square. So let's first talk about this HHS mandate. There's a lot of misconceptions out there about what this HHS mandate is, what it requires, and what the current play of affairs is with the mandate. Let me start with a quote by Professor Marianne Glendon. She's actually on the board of the Becket Fund. She's a professor at Harvard Law School. She was also the former ambassador to the Holy See. Marianne is one of my heroes, and she wrote an op-ed in the Wall Street Journal recently where she said this: "The goal of the HHS mandate is not, as HHS has claimed, to protect women's health. It is rather a move to conscript religious organizations into a political agenda." Let's give a little bit of background on the mandate. Where did it come from? How did it arise? What does it require? And then we'll talk about the problems with the mandate. So as many of you know, the Affordable Care Act, otherwise known as Obamacare, requires group health plans to provide preventive services. But the statute, as it was passed by Congress, actually left the decision to the Department of Health and Human Services to define what exactly that meant. What are preventive services? What should be covered under this act? And so to determine what preventive services should be required, HHS turned to the Institute of Medicine. And the Institute of Medicine convened a panel with many pro-abortion policy makers on it, some from the Guttmacher Institute, some from other institutes with ties to Planned Parenthood, and other groups. And the Institute of Medicine came up with some recommendations which they sent back to the Department of Health and Human Services, which were adopted in full and were put into the administrative rule, which then became the mandate. Now, there are many recommendations in this list that are completely benign, that have no apparent religious connotation. Diabetes screenings, gestational screenings, mammograms, that sort of thing. But it's the last requirement that causes concern, and that is the requirement that all group health plans must provide contraception, abortion-inducing drugs, and sterilization, as well as education and counseling about all of these things. There is a very, very narrow religious employer exemption from the HHS mandate, and it defines religious employer as follows. And you have to meet all 4 of these prongs to be able to be defined as a religious employer and thus be exempted from the mandate. A religious employer, according to HHS, is an entity that is exempt not only from paying taxes, but also from filing a tax return. Second, it's an entity that inculcates religious values as its purpose. And third, which primarily employs. And fourth, which primarily serves people of its own faith. Now, this exemption will in reality only apply to a very small group of churches and religious orders that have a very narrow scope. There are many religious organizations, including schools and colleges and hospitals and charitable organizations, that will fail to meet this narrow definition of religious employer. Now, I should add that exemptions are not new. Exemptions are a very healthy part of lawmaking, and explicitly religious exemptions have been written into many laws. So it's not something new that we're asking for an exemption that would protect religious freedom in this context. Our country has a very long history of granting exemptions for religious belief. Like for the Quakers who couldn't fight in the military. General George Washington gave them exemption so they didn't have to fight. They could serve in other ways. Or for those who couldn't work on certain days of the week. The Supreme Court has recognized the ability of those folks to get an exemption from being forced to work on certain days of the week. Or those who could not pledge allegiance to the flag. Or corrections workers who could not be involved in capital punishment. Or healthcare personnel who couldn't be involved in abortion. The list goes on and on. So we have a very rich tradition in this country of recognizing that religious conscience should be recognized. Now, this unprecedented attack on this notion of conscience and religious freedom that is part and parcel of the HHS mandate has produced a whole bunch of myths about what this mandate really is and what it requires. And I just want to dispel a couple of those myths. The first myth, I think, is that this is all about access to contraception, that we really need this mandate to make sure that people have adequate access to contraception. And what's really striking about this is that even the government in its own statements has acknowledged that contraception is available widely. There are some statistics from the Guttmacher Institute that actually says 9 out of 10 employer-based plans in the United States already offer contraception. It's available through community clinics. It's available on the internet. It's available through Title X funded government clinics. So this myth that this is really about making sure that everyone has access to contraception is really nonsense because it is widely available. What it's really about is forcing religious objectors to pay for it against their conscience. That's really what this is about. The second myth is that this is somehow related to federal funding. If you're a religious charitable organization, say a homeless shelter, and you may get some federal funding to help support your budget, that's why this mandate applies, because you receive federal funding and so therefore you are subject to this mandate. But in truth, that's completely false. This mandate applies even if every single dollar of your budget comes from private funds. This mandate will apply. So this idea that this is somehow tied to federal funding, which then requires these organizations to comply, is simply nonsense. And there's a third myth about the state contraception mandates and the fact that I think about 28 states in the country have some contraception mandate out there, and the administration has defended this HHS mandate on the grounds that they've said, look, all these other states, they already do it. This is nothing new. We're just following what the states have already done. But that is also a myth. If you actually look at the state mandates that require contraception to be covered in various plans, the federal mandate is unquestionably broader in scope and it's narrower in its exemption than all of the 28 states' comparable laws. Of the states that have a mandate, there are 19 that provide an exemption for the exercise of religious freedom. And of those 19 states with an exemption, only 3, California, New York, and Oregon, define the religious freedom exemption nearly as narrowly as the federal one. But even in California, New York, and Oregon, religious organizations can opt out through self-insurance. So even in those states with an exemption as narrow as the federal one, there's a way out for religious organizations. And even in states where there's a mandate when there's no express religious exemption, again, religious organizations can opt out through self-insuring or dropping their prescription drug plan. So there are ways out of these mandates in states, even if there are no exemptions expressly written into the state mandate. But the HHS mandate has none of these alternatives. There is no way out of the federal mandate. There is no way to move beyond the reach of the rule, and therefore it infringes more on religious liberty than any of the state's policies. So you may be wondering, so what's the big deal? You know, why don't they just not provide the coverage, and what's the penalty? Well, the penalty is actually quite stiff. If a religious organization stops providing health insurance because it can't comply with this mandate, it will be forced to pay $2,000 per employee, and that's just the first year. So for the 4 clients that the Becket Fund represents in our current litigation, that ranges anywhere from $300,000 to over $600,000 the first year, and those penalties will increase in subsequent years. So these are stiff financial penalties that are meant to be crippling, they are meant to be coercive, and they are meant to coerce these religious organizations to comply with this mandate. Otherwise, they will be subject to these stiff fines and potentially be forced out of business. If you can think about some of these homeless shelters or soup kitchens or other charitable organizations that have shoestring budgets that are not able to fork over such high penalties, financial penalties, it could literally mean staying in business or closing their doors. So what is this compromise that we've heard so much about? You know, in January, the Department of Health and Human Services issued a statement that there would be no change to the narrow scope of the exemption. And after that, there was really a firestorm that erupted. What HHS said, instead of expanding the exemption, they would give religious organizations a year to comply with the mandate. It's like, you know, we'll give you a year to get over your religious beliefs. And, you know, it's kind of like saying to Sir Thomas More, we'll give you another year in prison to convince yourself to violate your integrity. You know, it's kind of the same thing. And this set off a firestorm of opposition. And so you probably saw in February the press conference where the president himself got before the microphone and announced a so-called compromise. But this compromise really is a hollow promise in many regards, and I will lay that in a minute. But what I want to emphasize here is that at the same time that the administration was announcing this so-called compromise at the press conference, the very next day, the mandate with its extremely narrow exemption was finalized as a final regulation in the Federal Register and enacted into law with effect to begin this August. So at the same time that they're saying, well, we're going to fix this by changing it and making it better, they finalized the very mandate that caused all of this to begin with. And so the president made 2 promises in his press conference. He said that enforcement of the mandate would be delayed by a year. And second, he said, in a rule yet to be developed, we will shift the cost from the religious organization onto the insurance company. And the insurance company will be the one who will provide and pay for these abortion-inducing drugs, sterilization, and contraception. But the problems with the compromise are many. First, anyone who understands basic economics knows that insurance companies, if they're forced by the government to pay for these services, will not then offer them to customers for free. That's just basic economics. Religious employers would still ultimately have to pay for these services, even against their conscience, with the costs spread to these religious employers through higher insurance premiums to cover their employees. Some argue that insurance companies would cover these services at no charge because it helps their bottom line. But if that were the case, then why haven't insurance companies already done this? If it would help their bottom line, why haven't they already adopted this policy and provided these services for free? And the answer is they obviously haven't. So the economic pressure would really have already solved this problem if those suppositions were true. The second problem with the compromise is that hundreds, if not thousands, of religious organizations self-insure, which means that they are the insurance company. And when that's the case, the new compromise offers them nothing. And ironically, many religious organizations self-insured to avoid the effect of state contraception mandates, where self-insured organizations are exempt from the rule. So religious organizations self-insure to get out from the reach of the state contraception mandates now find themselves subject to this federal mandate with a new compromise that suggests that they're going to shift it onto the insurance company. They're self-insured. They are the insurance company. So there's really no compromise or no solution for them there either. And third, there's no evidence that even under the new proposal, non-exempt religious organizations, for-profit entities that are run by religious individuals, and non-denominational organizations, there's no evidence that any of these groups will be protected in their religious freedom at all. So this last month, the advance notice of proposed rulemaking was issued by the Department of Health and Human Services, and it lays out several ways that this so-called insurance mandate could go forward. There have been many comments that have been submitted by religious organizations, by insurance companies, by an organization called the Self-Insurance Institute of America. They have all pointed to the fact that these ideas that have been floated as a possible solution to this mandate will not work. They are impractical, they are sometimes illegal, and even one major insurance company has already called the proposed insurance mandate unworkable and inadvisable. So today we stand no closer to a remedy to this serious infringement on religious freedom than we did before the February press conference. So we have 4 current lawsuits that are pending in federal courts around the country. We filed lawsuits last fall on behalf of Belmont Abbey College, a small liberal arts school in North Carolina that was founded by Benedictine monks. They were our first plaintiff challenging this mandate. We also represent Ave Maria University in Florida, another great Catholic school. We represent Colorado Christian University, which is a non-denominational evangelical Christian school in Colorado. And I think that's a really important point to make, that this is not just a Catholic issue. This is an issue that affects people of all faiths. And there are indeed actually 3 current cases pending right now by institutions that are evangelical or traditional Protestant to underscore the point that this affects people of all faiths. And then we also represent EWTN in Alabama. We are representing them in a lawsuit also. So we are pressing forward with our 4 lawsuits. As of late May, there are a total now of 23 lawsuits. I'm sure many of you have heard in the news of the several lawsuits that were filed by Jones Day on behalf of many Catholic entities around the country. So there are a total of 23 in 14 states and the District of Columbia, representing 55 plaintiffs. There are 3 for-profit companies and 3 non-Catholic institutions, as I mentioned before. On Thursday, we're going to have a very significant ruling by the Supreme Court deciding the individual mandate case. That's a separate mandate. That's the mandate that would require individuals to purchase health care. But a very important question in that case is, if the individual mandate is found unconstitutional, can you sever it from the rest of the law? Can you remove it and leave the rest of the law standing? And if they decide to sever it and leave the rest of the law standing, then our cases will continue. We will move forward and continue to challenge this mandate. If they decide that no, this individual mandate is so significant and it's the heart of the healthcare law, we really can't sever it, otherwise the rest of it falls apart, then they might decide that the entire healthcare law has to fall with the individual mandate. And in that case, the healthcare law would then be deemed unconstitutional in toto, and we would have an automatic win in our 4 HHS mandate cases, which would be a great result. So we'll wait with bated breath on Thursday. Just one final observation about this HHS mandate. This argument that the government has actually considered all the interests and struck an appropriate balance is difficult to credit. There have been twice now, 2 times, when Secretary Sebelius has been questioned before 2 different congressional hearings, and she's been asked questions about this mandate. And on 2 different occasions, under oath, she has testified that she did not consult constitutional precedents, and she asked for no legal advice from the Department of Justice when she was making her decision about this mandate. Now, I find that utterly breathtaking, that a secretary of a Department of Health and Human Services would not even ask the Department of Justice whether or not this mandate that she was about to impose would be unconstitutional or have legal infirmities based on American law. So she's admitted that under oath. As Michael Gerson wrote in a recent op-ed in the Washington Post, he said, "The only thing worse than indifference to religious liberty is casual, ignorant indifference to religious liberty." So let's move to the second threat. This one is based on the freedom of churches and faith-based associations to organize and choose their leaders based on religious criteria. And here I'm referring to the case in January that many of you may have heard about, called the Hosanna Tabor Evangelical Lutheran Church and School versus EEOC case that was before the Supreme Court. The Becket Fund actually worked on that case. We collaborated with Professor Doug Laycock at the University of Virginia Law School, and together we briefed that case before the Supreme Court. And the issue in that case was, what is the right of churches to choose their own leaders in the face of these various federal anti-discrimination statutes that have been passed by Congress to protect against discrimination in the workplace? And what is that right, and how far does it reach? And so let me give you a little bit of background on this. There was about 40 years worth of precedent on the books where the federal courts of appeals around the country had all recognized that the Constitution protects this very special relationship between a church and its ministers in their hiring practices. And because ministers are the lifeblood of churches, the Constitution recognizes that it has to protect a church's ability to hire and fire and define who represents it in its mission. So our case dealt with a fourth grade teacher, and I won't go into all of the details because of time, but she had been fired for basically not adhering to a doctrine of the Lutheran Church, which required her to resolve disputes, especially disputes involving the ministry, within the Lutheran Church. They have a very elaborate internal dispute resolution system set up to resolve these kinds of conflicts so that Lutherans are not supposed to sue other Lutherans in civil court, especially over ministry issues. And so we got to the Supreme Court, and the question was, well, would the ministerial exception that has been acknowledged for 40 years in the courts of appeals, would it apply to this fourth grade teacher? Well, let me just be clear. The constitutional ministerial exception protects very important religious practices like the all-male clergy in the Catholic Church and in the Orthodox Jewish faith as well. It protects religious rules about ethnicity and descent in some branches of Judaism and Islam and Hinduism. And so without this constitutional protection of the ministerial exception, those very religious practices would be at risk. So the real fundamental religious liberty issue at stake with the ministerial exception was the right of churches to evaluate and select their own leaders free from government intrusion. And here's where we get to the threat. So we get to the Supreme Court, and all along this case has been briefed, sort of assuming that the ministerial exception existed. But we get before the Supreme Court, and the government's lawyer, the Solicitor General, the lawyer who stands up and represents the position of the United States government to the Supreme Court, he gets up and he argues that there should be no ministerial exception at all, that there should be no recognition that there is a special relationship between a church and its minister, that churches should be treated like labor unions or other social clubs, that they should be protected to no greater extent than any of those other social organizations. So this was a head-on attack, challenging the very existence of religious autonomy in the hiring and firing of ministerial employees. And fortunately, it became clear in oral argument that the majority of the justices rejected this extreme position. And even Justice Scalia, you gotta love him. I mean, the guy's just great. And he, in oral argument, he said, I'm gonna read you his quote because it's so darn good. "We are talking here about the Free Exercise Clause and about the Establishment Clause, and you say that they have no special application. There is nothing in the Constitution that explicitly prohibits the government from mucking around in a labor organization. But there, black on white, in the text of the Constitution are special protections for religion, and you say that makes no difference." And even more telling, however, was the response from Justice Kagan, who was just recently appointed by President Obama as Solicitor General and then to the Supreme Court herself. And she agreed with Justice Scalia in oral argument, and she said, "I too find that amazing, that you think that neither the Free Exercise Clause nor the Establishment Clause has anything to say about a church's relationship with its own employees." So realizing that this first line of attack was not doing so well, they fell back to their second line of attack, which was, even if there is a ministerial exception, it should be limited to only those employees who perform exclusively religious functions. So this definition was so narrow that the Chief Justice of the United States broke in and said, "That can't be the test." He said, "The Pope is a head of state carrying out secular functions, right? Those are important. So he's not a minister?" Luckily, it was a 9-0 opinion, a unanimous Supreme Court. And they rejected these arguments that the government was putting forth as extreme. These are direct quotes from the opinion: extreme, remarkable, and untenable. It held instead that there is a ministerial exception that protects broadly this right of churches to choose their leaders free from judicial intervention. But the threat continues because there's another Supreme Court case called Christian Legal Society v. Martinez, which was decided earlier than Hosanna Tabor. And basically in that case, the court said that in a publicly funded school, you can have an all-comers policy, which basically says that if you're a student organization at a school, you have to allow people of any faith or no faith to join your organization. And furthermore, you have to allow them to be your leaders if they want to be. So that policy, unfortunately, was upheld by the Supreme Court, and we have already seen that policy been implemented in even non-publicly funded schools. For example, you may have seen news reports recently from Vanderbilt, which of course is a private university, but has a similar all-comers policy. And there, the Catholic student group on campus has basically been forced off campus because they will not comply with this all-comers policy. So this is a real threat that continues, notwithstanding our victory in Hosanna Tabor, which was a huge, wonderful victory. But there is this continuing concern, especially over student organizations under the CLS precedent. So this is a threat that we need to be ever vigilant about, protecting the right of religious organizations to self-define, to be autonomous in their ability to choose who their leaders are. So this third threat that I'll just touch on briefly is the threat to students, healthcare workers, other professionals to perform certain acts that violate their conscience. There's so many examples here, unfortunately. Religious pharmacists who are required by some state laws to provide abortion-inducing drugs, even when doing so violates their conscience. Religious wedding photographers who are fined by the state for declining to photograph a homosexual wedding ceremony. Religious nurses who are forced to assist in performing late-term abortions or risk losing their job. Religious graduate students who are threatened with expulsion if they don't counsel homosexual couples, even when referrals to other counselors are permitted for other professional reasons. And religious government clerks who are forced out of a job because they can't, in good conscience, sign marriage certificates on behalf of homosexual couples. We recently won a really important case in Washington State. It's called Stormans v. Selecki. It's on behalf of two Catholic individual pharmacists and a 4-generation family-owned Catholic pharmacy in Washington. And they challenged those state regulations that would force them, against their conscience, to dispense abortion-inducing drugs against their conscience. And we won. And we got the federal trial court to acknowledge that this policy violated the First Amendment because there were so many other exemptions for secular reasons. The state board was perfectly fine with pharmacies not stocking and dispensing drugs if they had too short of a shelf life, rather. They didn't want to stock them because they had too short of a shelf life. Or they didn't like the client's insurance, so they just wouldn't dispense the drugs to them because they didn't like their insurance. There were all these reasons that for secular purposes they could refuse to dispense drugs. But if it was a religious one, that wasn't okay. And the federal district court there said that that violated the First Amendment. We're now on appeal before the Ninth Circuit in that case. But that's going to be a significant one. And there's also a case in Illinois that's similar to that, that's ongoing as well right now. Finally, the last case I want to discuss is just the Pledge of Allegiance case out in the Ninth Circuit. These threats by I think, hyper-secularist groups to scrub out all references to God or religion in the public square. The Pledge of Allegiance case is certainly one of those. Other cases include trying to take away religious symbols out of military cemeteries or destroying military veterans' memorials that carry crosses, etc. The Newdow v. Carey case was one that we worked on in the Ninth Circuit. You probably heard that the Pledge of Allegiance case went up to the Supreme Court a while back, but you may not recall that it was decided on a technicality there, and so it was sent back down to the Ninth Circuit. And the phrase, "one nation under God," was still in peril in that suit. And so we intervened on behalf of some students and their parents, and we defended against this renewed attack by Dr. Michael Newdow, who's an atheist activist who had campaigned to remove the words "under God" from the pledge. And what we argued in that case was that the words "under God" in the Pledge of Allegiance affirm a foundational premise in the American political tradition of law and rights, namely that human rights are not bestowed by the state, but are rather derived from a source beyond the state's discretion. So "under God" does not unconstitutionally advance religion, but rather reflects the deeply rooted political philosophy of the Founding Fathers, who believed these rights derived from a source greater than government, greater than a government made of men. The pledge was also defended by the Justice Department, and they defended it on other grounds. This is a theory called ceremonial deism, which basically means that the words "under God" have been repeated so frequently that they've lost all religious meaning. So after considering the case for 2.5 years, which is an incredibly long time for a case to be under advisement, the Ninth Circuit actually reversed itself. Initially, when it heard the case, it found the words "under God" unconstitutional, went up to the Supreme Court, came back down again. We got involved. They reversed their position, and the Ninth Circuit said they would keep the words "one nation under God" in the Pledge of Allegiance. And in its reasoning, they adopted our political philosophy argument. We, just this month, won another pledge case up in Massachusetts, where another group was trying to challenge the Pledge of Allegiance up in Massachusetts, and we won that case just this month as well. So we're continuing to defend against these attacks to try and remove religion from the public square. Let me just close by this great quote from Cardinal Francis George, who was then president of the U.S. Conference of Catholic Bishops. And he spoke at Brigham Young University in Utah last year. And this is what he said. He said, "In the coming years, interreligious coalitions formed to defend the rights of conscience for individuals and for religious institutions should become a vital bulwark against the tide of forces at work in our government and in our society to reduce religion to a purely private reality. At stake is whether or not the religious voice will maintain its right to be heard in the public square." So I would encourage you, as Cardinal George encouraged us there, to get involved, to write your congressmen and senators, to become educated on the issues, to write letters to the editor, to talk to your friends about this issue, to vote on issues that matter to you when it comes time to do so. There are so many ways that everyone can be involved in this great fight to defend our religious freedom. And I implore you, we need you. We need your energy, we need your support. And thank you very much for your time tonight. It was a great time to be with you.